I'm what's called a will writer, is the simple term, but I'm not here tonight to promote my services. The theme of the talk is dispelling myths and money-saving tips in and around the areas in which I work, which is wills and powers of attorney and probate and care fees. I started originally up in the Midlands in 2005, relocated in 2012, started again effectively, worked part-time for Royal Mail, that's how I know Teresa, because we both worked there at the same time some years ago, so as I built up my client base in this area, but we now have consultants up in the Midlands and hoping to take some more on as time goes on. But it's not going to be a lecture about what people should or shouldn't do. It's very much, did you know this, did you know that, etc. I'll talk for about 20 minutes, and if you want to ask any questions from a general point of view, please feel free. The camera is filming me tonight, if no one has any objections, because it helps other consultants. I can show them how I do these talks. But if you want me to turn the camera off when you're asking questions, I'm happy to do so. But it's not recording any of you, it's just recording myself today. So I'm going to start off just with some very general pointers. For example, a lot of people will always ask, oh, do you charge VAT? So when you're looking at anything to do with legal services, whether or not you pay VAT depends upon the size of the company you're using. Because if the company's income is more than a certain amount, you'll have to pay them VAT whether you like it or not. If you use a smaller firm, you see myself, where the income to the company is below a certain level, you don't pay VAT. So you can actually save yourself 20% on any fees you ever pay purely by using a suitably qualified and insured practitioner whose income is a little bit lower. So if you haven't, I haven't got huge palatial offices in Exeter, loads and loads of staff, because that's basically what you're paying for, and VAT will always apply. So you can save yourself 20% if you just shop around and look perhaps for a smaller, suitably qualified practitioner. I'm going to start with wills generally and areas around that, touch then a little bit upon powers of attorney, probate, finish on care fees, because there's lots and lots of myths that perpetuate around those areas. Something I get asked a lot is, well, what happens if I die without a will? People here may know, may not, and I appreciate that I'm not going to baffle you all with knowledge that you've never heard before, but most of you will pick up something that you may not be aware of. If we die without a will, it depends upon our marital status, but if there's no will, when we die, if we're married and we have children, then all our personal belongings will pass to our spouse, and then the first £270,000 worth of our assets will also pass to our spouse, and any excess value above that is split 50% to our spouse, 50% to our children, whether or not your spouse is the parent of your children or not. And this causes a lot of inter-family disputes, because somebody may have been widowed earlier on or divorced, and then they remarry, and the person they're married to is not the parent of their children. Without a will, the vast majority of an estate would pass to your spouse, and surprisingly that spouse is generally reluctant to pass back money to their stepchildren, being my own children in that example, because they're going to naturally favour their own children. So without a will, you can end up by accident disinheriting your own children from a large proportion of your estate, purely because you don't have a will that says you want something else to happen instead. So it's really, the law doesn't always work in our favour. Also, if you're estranged from any of your children, then your estranged children will also inherit under the law whether you want them to or not. When you have a will, of course, you can then cater for that to make sure that doesn't happen. Also, if you don't have a will, then no money will go to anybody else, such as charitable organisations or friends, other members of your family that you want to make gifts to. Without a document confirming that, the law will just say vast majority to your spouse, the remainder to your children. If you're not married, then everything will go equally to your children, your biological children. A lot of people also are unaware of the fact that having a will, the term valid will is very important. And I come across this a lot, where I'll meet somebody who was married to somebody else years ago, may have become widowed, or they have become widowed, and then they remarry, but they can still see the will they had with their first spouse, and they say, that's fine, I've got a will because I wrote that years and years ago before my first spouse died and I remarried. They don't realise that remarriage revokes all previous wills. So that's what happens, where people will just rely upon an old, invalid will until it's too late, and again, the new spouse is delighted, absolutely delighted, because they're the majority. Children of the deceased not very happy, because they don't understand why they're not inheriting, because their father or their mother was relying on a document that they could see but was no longer valid because they didn't know it had been invalidated by marriage. But the same does not apply for divorce. So if we divorce from somebody, the will is still valid, it just means the person from whom we are divorced is treated as if they've died. So they can't inherit, they can't act as an executor, etc. So it does leave holes in a will, but it doesn't automatically invalidate a will. But marriage does. Be very aware of that, because I come across a lot of family disputes because people didn't know that until it was too late. Can an executor be a beneficiary of a will? That's a question that's asked of me a lot, and that stems from a slight miscommunication, or what they used to call Chinese whispers, because people say all the time, well, I can't have my spouse as the executor because they're a beneficiary, and I'll say, yes, you can. What they're confusing it with is when you sign your will and you have to have your signature witnessed, a witness cannot be a beneficiary to a will. So it gets confused over the communication, people start to get them too confused, and all that happens is that if one of your beneficiaries witnesses your will, it doesn't invalidate the will, it means that beneficiary cannot inherit. And that's why you never see a cheerful witness, because they're not going to inherit from the will. So an executor can be a beneficiary, it's the fact that a beneficiary cannot be a witness to a will. A lot of people are also under the impression that if you've got a will, then nobody can contest your will, which is not true, that's a myth. Anybody can contest your will, but whether or not they'll be successful is a different matter, which I'll come on to in a moment. So merely having a will is not a defence against people contesting your will further down the line. I'll touch upon that in a few moments' time. It happens, sadly, that a lot of families will have estrangement and disputes within the family, and people will say, oh, I'll give perhaps the most common example is where you've got estranged spouses. So you've fallen out with your spouse, you're no longer on speaking terms, but you're not yet divorced. Well, if you just write a will to say, I leave everything to my children, that's not enough, because your spouse can then contest that on the basis you haven't clarified the fact that you don't want to leave anything to your estranged spouse. And the same principle applies with estranged children. Just ignoring somebody in a will does not work. You have to specifically point out the fact you are aware you are not providing for someone, because otherwise they just easily go to a court and say they forgot or they made a mistake. So you have to spell it out in the will and accompanying documentation. I'm not providing for my spouse, I'm not providing for my son, my daughter, etc. And the reasons are as follows, because otherwise courts are lazy and they'll just say, well, there is no evidence to suggest that it isn't a mistake, and they start carving up estates and giving it out to more and more people for equitable reasons, even if it's not what you wanted. So if there's somebody, a close family member that you do not want to inherit from you, you must make that crystal clear in your will, not just ignore them and not mention them, because that won't work. The location of your will is very, very important, again, when it comes to family disputes. Let's say you've got an estranged child who would stand to inherit £300,000 or £400,000 had you left anything to them in the will, but you've decided not to. If somebody who is disadvantaged as a result of that, they are estranged, that you've cut them out of your will, if they can get to your will before anyone else does and destroy it, if they know anything about the law and they know what they would stand to inherit, it does happen. Even though it's illegal, it's very difficult to prove. So if there's any contention or potential contention within an estate where there might be somebody who you'd expect would contest your will, don't keep your will on the mantelpiece. Because if they get to it first and destroy the will, the law would then apply and all children would inherit under the law, rather than maybe an estranged person not being included. So don't just rely on it being under the bed or in a cupboard. If there's any potential for dispute, keep that will somewhere secure off your usual residential premises, because once it's been destroyed, the law assumes there was no will. Going back to executors, a lot of people will ask me and say, well, can my bank be an executor of my will, or can a solicitor be an executor of a will? And the answer is yes, of course they can, but they will charge handsomely for that. And we're talking hourly rates of £200 or £300 an hour, plus VAT. And strangely enough, it takes them many, many, many hours to carry out their executorship roles. So although, yes, it is sometimes an option if there's a very, very complex estate, Usually, if you appoint an executor who's a close family member, you're not expecting them to be experts in the law, because they can then take advice if and when they need to act. And they will, at worst, be able to reimburse themselves their own out-of-pocket expenses. They won't be charging you an hourly rate. And it's a lot cheaper. Nowadays, I come across it sometimes where people will say, oh, 5 years ago, mother died, put her estate through probate when there was no need to do so, it wasn't required, and the legal fees were £6,000 because an executor was a solicitor or a solicitor carried out the probate work. Very rarely do you need to use professionals. Most people do because they think, well, my spouse or my son or my daughter knows nothing about the law. Well, they don't need to, because they can take advice at that time, and they can shop around and say, well, where can I get guidance? There are firms out there that will provide probate guidance for a fraction of what your average high street solicitor will do. And there are firms, I'm trying to think of one locally, that I can't think of the name of any firm that provides probate guidance, but they do exist. But there are many other companies that will do that as well. So you don't have to commit to a solicitor when you write your will to be an executor, because it can be very expensive. Probate. We've probably all heard the term probate, and some of us may sadly have had to experience it through life deaths and members of our family who passed away. But probate is often misunderstood, because probate means permission to distribute an estate. And I'll give you an example. A lot of people think you've got to get probate, it's a foregone conclusion. It isn't. If somebody dies and they've got £15 in the bank and a car, their estate will not need probate, because the £15 will just be distributed by the bank happily to whomever is the beneficiary of the will, the next of kin, and the car likewise. However, if somebody owns property in their own name when they die, or they own property jointly with somebody else, but they own it in a certain particular way, and I'll come on to this in a moment, although they have significant value in a bank or a building society or an investment, well, the bank might say, Barclays Bank might say, well, we're not releasing £200,000 to you until you've got permission to actually distribute that, and that permission is also known as a grant of probate. So the permission is received from a department called the Probate Registry, where they give you a certificate to say, we now give you permission as the executor of the will, or the next or the legal representative of that person who's died if there isn't a will. You may now take that money from Barclays and distribute it to whomever are the beneficiaries. So it isn't a foregone conclusion. So people will, when they're saying, do we need probate or not, you wait until it's confirmed to you as an executor from a bank, or if there's property that needs to be sold, that will confirm that probate is required, because property obviously is a valuable asset. The land registry aren't going to just say, yes, you take it and do whatever you want with it. So probate is permission to share out an estate, which may or may not be required when somebody dies. I mentioned before that there's more than one way that two people can own a property together. I don't know if anyone here is aware of that, but the traditional way to own a property together is what's called joint tenants. Two people own a property equally as joint tenants, and for hundreds of years that's how two people own a property together. What that means is that when one of the co-owners dies, the survivor, by law, automatically inherits the whole property, 100% of it. The other way is what's called joint tenants in common, which means that you each own 50% of that property each. Now, can anybody think why that's an important difference in a circumstance where that might become a problem?
Remarriage.
Yes. Because if, let's say, Mr. and Mrs. Jones own the property together, Mrs. Jones died, and then Mr. Jones remarried Mrs. Davis, and Mr. Jones and Mrs. Davis became shareholders in that same property. Mrs. Davis bought into it, let's say, so they now, a new spouse co-owns the same property. If they own it as joint tenants, Mr. Jones dies, Mrs. Davis owns the whole property, including what she's inherited from Mr. Davis. Mr. Davis's children get nothing. Whereas if they own the property as joint tenants in common, they each just say, well, whenever I die, my surviving spouse can live in my share if they like for the rest of their life, but when they die, my share goes back to my children. But you can't do that unless you own the property as joint tenants in common. So whenever you experience anything to do with joint property ownership, it isn't always as simple as it may seem, because there are unforeseen dangers attached to that. Something that I always just point out to people, which you probably don't need me to do, but we are saturated all the time with adverts for free wills. Free wills. There's no such thing as a free lunch or a free will. And I always just make people aware of this. There's going to be a catch. There'll be a catch somewhere. So whenever somebody comes to you and says, yes, I'm doing this for the goodness of my heart, charities, for example, yes, they may well originally be creating the will free, but it will be dependent upon, for example, a large chunk of the estate having to go to the charity. The charity will then bombard you with requests for money thereafter, or it will be a professional locking their services in later on for probate services, etc. So the message there is always beware of so-called free wills, because there's going to be a catch somewhere. They get you further down the line, and you'll pay a lot more than you would pay just for a will if you were to pay for a will in the open market when you need one. Power of attorney. Now, I'm going to just talk again generally about power of attorney. Is everybody aware of what that means? So the term attorney means somebody who speaks for me. Myself included, a lot of people are under the impression that that is something for people when they get ill. But actually, that is not the case. I'll give you two examples of why power of attorney is so important in the modern world. 50 years ago, it was less of an issue, because 50 years ago, if, let's say, Mrs. Smith went to the bank and said, Mr. Smith has lost his mental capacity, the bank manager would say, well, don't worry, Mr. Smith will sort out his banking for you. All professionals now in institutions are petrified of being sued. So unless they have the legal authority to act for somebody who's lost their mental capacity, let's say, they won't do anything. And I'll give you two classic examples that I come across a lot, where you've got two people who own a property together. Doesn't matter how they own it together. One of them loses their mental capacity, they become very ill. And what that means is that house has to either be significantly adapted or possibly sold and another property repurchased to cater for an illness. They can't do that, nothing can happen, they're stuck in the property because one of the co-owners cannot sign to agree for it. So if you arrange power of attorney in advance and say, if one of us becomes ill in the future, I hereby nominate and have a document registered with the court to say that this person, my spouse, my partner, my friend, whoever it is, my co-owner, can actually transact on my behalf for my share of the property, problem solved. Because then, if somebody becomes ill, their partner who remains well, or their spouse who remains well, can actually adapt the property or can sell the property on behalf of the person that's ill. If you don't have power of attorney for property and financial affairs, that will not happen. And once somebody's lost their mental capacity, it's nigh on impossible to get permission retrospectively. It's possible, but it's very, very expensive, it takes a long time, there's no guarantee of success. So that's one area where power of attorney, even though we're all fit and well now, we may not be in the future, and if we don't have somebody else who can act for us, and after it's too late, it causes a lot of problems for many family members. Another issue is more to do with care fees, which I'll come on to in a few moments, but under the NHS, we are legally entitled to free health care if our need for care is primarily health related. So the NHS, who don't want to pay for our care in the long term because it's very expensive, will always push us down what's called the social care route. There's two different types of care in this country. There's health care, we're all familiar with that, whether it's putting a cast on your ankle when you break your ankle, right through to dementia and long-term degenerative diseases. The NHS will provide health care in those examples. And there's social care, which is somebody now finds it a bit difficult to get on the bus to go to the shops, so they'd like to live somewhere nearer the shops. That's a social need because they're actually not in need of residential care, it just is convenient for them. Whereas somebody who can't feed themselves, can't breathe at night if they fall over because they can't move, that's a health need. So what the NHS does is they class everybody from the starting point and say, oh no, this person doesn't need health care, they need social care, and then wash their hands of it. And 99% of people accept that and say, oh, fair enough then, we'll use our assets to pay for our care when they're legally entitled to free health care. And the NHS will only relent when people appeal that decision. Now, if somebody's lost their mental capacity, they cannot appeal that decision. It's too late, they're not capable of it. But if they've given somebody in advance power of attorney to act on their behalf for their health and their welfare matters, that person can then appeal an incorrect decision and hence reverse the process so that that person will get free healthcare if they're entitled to it legally. So the default is the NHS, no 100%, right down the line. Doesn't matter how bad condition a person is in, and I've seen some really ludicrous decisions where the NHS are trying to justify that a person who is basically in a vegetative state only needs social care, which is ridiculous. So having somebody who's appointed as your official power of attorney for your health and your welfare will solve that problem, and that's only going to get worse. Because we're sleepwalking towards, I don't know who's going to pay for all this care that we're all going to need in 20 or 30 years' time, but someone's going to have to, and it will be just convincing people they've got to sell their house to pay for their care when they needn't. So I would say when it comes to care, whether it's ourselves or anybody else, don't agree to anything, don't sign anything without taking independent professional advice first. And even my own clients don't adhere to that. I get calls from time to time, people saying, oh, do you remember when you told us about care, not to agree to anything, not to sign anything before we spoke to you? I'll say yes, and say, well, we put Mother in a home 3 weeks ago, and now they've charged us £12,000. I'll say, well, that's not, you're not speaking to me before you made a decision, you're speaking to me afterwards, and that becomes a lot more difficult. So be aware that you've got rights and take advice. Whatever you're told by the NHS and the local authority, ignore that until you know your rights, or the rights of the person who's become ill. So we've covered all of those. So jointly owned properties. So I'm just making sure I haven't missed anything. Inheritance tax. I'm just going to touch very briefly on this. There are varying different scenarios for inheritance tax, but very few people are actually subject to it these days, because if you take somebody who's a widow or a widower and they have children, when they die, they can pass up to £1 million worth of estate value free of inheritance tax. I'm not going to bore you with all the allowances, but a widow or a widower with children can pass up to £1 million worth of estate value free of tax. A single person with no children can only pass up to £325,000 of estate value tax-free. I'm not going to bore you with why that is. Inheritance tax affects far fewer people now than it did before 2007, because what happened before 2007 is that if a spouse died, they lost their allowance, and their surviving spouse only have their own individual allowance left. In 2007, that all changed. Surviving spouse can now use their deceased spouse's allowances as well as their own. So they're claiming double the amounts that they used to be able to. So I'm boring myself down that topic. So inheritance tax.
Does that not only make 650 though?
No, it's up to £1 million, because if you're passing your residential property down to direct descendants, our own children, grandchildren, etc., there's an additional £350,000 worth of allowance. So anything up to £1 million now. That extra allowance was brought in about 4 or 5 years ago. But it's worth knowing, because I've known, not through my services, I hasten to add, but I've known people who've not known that. And if you say to the revenue, we owe you £200,000, they're not going to turn it down. Even they're not going to say, oh, did you know you've got this allowance and that allowance available to you? They'll just say, thanks very much. Trusts always conjures up expense and complexity to people. People think trusts, oh my word, that's expensive, it's complicated, that doesn't apply to me. A trust is a very long spectrum of different options, starting with parents or grandparents who will open an account for a child or a grandchild and say, we'll put £50 a month into that, and when they're 18, that's theirs. That is a trust. Simple as that. No costs, no complexity, that is a trust for a child or a grandchild. Right through to, I deal with increasing amount of cases where I've got a case at the moment where one of the sons of a widower is going through the process now of a divorce, and the woman that he is becoming divorced from keeps saying, I'm taking all your father's estate from you as well. Obviously, a lot of strong feelings, a lot of emotions attached there. But what father is now doing is he's creating a will, so he'll say, well, if I die before the divorce is settled, what's going to my son who's going for the divorce will go in a certain way, which means she can't get hold of it. That is a trust. But it's done simply in a will, really, that there would be some formality after the father's death if he dies before the divorce is settled. But again, not complex. It's just saying, well, I don't really want my estate to go to the estranged wife of one of my children, and all I have to do is make sure my will makes that clear. And it's not a default, it's not standard. That's a trust. And then you've got all these complex company trusts and family trusts, which I'm not even going to touch upon. It's horses for courses. There are trusts that will suit certain scenarios that are not necessarily expensive or complex, but they're increasingly important to protect assets through generations. Because if you leave everything to one of your children, who then becomes divorced later on, what you've passed to them could be lost in a divorce settlement. So it isn't always as simple as it used to be many, many, many years ago. Just make sure I'm not missing anything. Oh yes, something else that is also worth knowing is that after a person dies, we have up to 2 years after their death to vary the terms under which we inherit from them if we so choose. And it could be to do with avoiding means-tested state benefits, as an example. So if money passes to somebody who's receiving means-tested state benefits, could affect their benefits. So that person can actually say, well, I don't want that because it's going to affect my benefits. That person can say, I want to vary the terms under which I inherit so it doesn't affect my means-tested benefits. Divorce, again, that can still happen up to 2 years after someone's died. It's more expensive, but it can still be done. So once somebody dies, that's not the end of the story. Beneficiaries, if it suits them and it's to their advantage, can actually vary how they inherit from that person to improve their position. So it's called a deed of variation, and you've got up to 2 years after the date of death to vary that. And I'm now going to finish, as far as my talk is concerned, and we can cover any questions that you may have, is going back to what we were talking about regarding care. Just to be clear, there are 2 different types of care that we are eligible for. Number 1 is health care, number 2 is social care. Now the reason I'm coming back to this is that everybody will be pushed down the social route, because what that states is, if you have assets greater than the value of £23,250 and you need care, you must use everything above that amount to pay for your care. The state will pay nothing. So you have to dwindle all your assets down, and it may or may not include your property. So if you've inherited a property from your deceased spouse, absolutely from them, and you're living in it and you're the sole owner of that property now, that whole property, and you live alone, that whole property can be taken to pay for your care. If somebody else lives in the property with you, who's close to you, or a family member over the age of 60, the house cannot be taken. So what I'm touching on here is there's lots and lots of different rules and regulations, and this is why you should always take professional advice before agreeing to anything with care, because I've come across cases where people who shouldn't have had to sell their house did sell their house. Didn't realise that somebody who was living in it with them meant it was exempted from the calculation, and the nasty local authority, who was only interested in money, didn't tell them that, because they're motivated purely by financial gain rather than what's right for that person. So everybody is naturally pushed down the social route to pay for their own care. Don't accept that just because you're told that. People will be in hospital, they won't be told that the person they're speaking to is a representative of the local authority, not an NHS employee, and the local authority is trying to get their money from them. They don't understand that, they don't realise that, so they sign documents, they agree to this, that and the other, and then trying to get money back that's been wrongly paid is really difficult. Really difficult. You've got to jump through so many hoops. Better not to pay it in the first place, because then you can keep it in the family, keep houses that shouldn't be sold, etc., etc. My literature is here, so please feel free to take it. But all I can say is know your rights when it comes to care, because it's not what you will be told by the care representatives. They will tell you whatever they need to get your money. A couple of years ago, a client of mine who was partnered, or her and her partner, they weren't married, they'd been together for a long time. She owned the majority of the assets between them. He lived in her house, and then he needed to go into care. And it was a privately run care facility, and the owner of the facility told her that as they'd been living together as man and wife for 20 odd years, that she had to pay for his care, which was illegal, because we only pay for our own care, we don't have to pay for anybody else's. So people are told anything to get hold of their money, and once you pay that money out, you try and get it back, it's very difficult. Prevention is much better than cure, because trying to get it back is a nightmare. And I'm just making sure I haven't missed anything. So in summary, those are just a few areas that I deal with on a day-to-day basis. There's many, many more, but I'm not going to sit here listing them all out for an hour and a half, because it gets a bit tedious after a while. But a will is no longer simply a list of who gets what. It can protect assets through generations, it can avoid accidental disinheritance, it can do all sorts of things that people didn't need them to do 50 years ago, but very important now. Power of attorney, if I had a pound for every time I had a client saying, yes, I'll be doing that soon, I'll definitely be doing that soon, they then have a stroke, too late, and the people around them are the people that have the problems, not them. The people around them now have to go to the courts and say, please can we have some permission to deal with this person's affairs, thinking about it, umming and ahhing, money. It becomes a very unpleasant situation. With power of attorney, it's relatively inexpensive, and hopefully you'll never need it. But it's better to have something that's relatively inexpensive that you don't need than having to need something that you haven't got that suddenly somebody has to pay a fortune for. So power of attorney prevention again is better than cure. Probate we talked about, which is it isn't a foregone conclusion. Don't just apply for probate thinking you've got to, because you may not need it, and you'll save yourself a lot of money there, especially if you're considering using a solicitor to carry out probate for you. I would say shop around for smaller, more cost-effective options. As I say, I'm not here to promote my services today, but if anybody has any questions either tonight or wants to speak to me privately, I don't charge consultation fees. There is no obligation. That's genuine, because I don't like being put in a position where I feel I'm being pressured to buy something, so I don't do it to anybody else. People come to me and say, I've got a question, I'll happily answer them, because my business is successful, or our business is successful, sorry, because we speak to many people, not always generating income for us in the short term, but longer term, people are more comfortable to go back to a firm where they felt they weren't under any pressure. And that's the way we work. So no obligation, no consultation fees, confidential, and we do make home visits within reason. Obviously, somebody phoned me up from Ipswich, I probably have to say, well, probably not, it's probably somebody closer, but within reason, we'll visit people in their own home, and as I say, it's all confidential. But we do have meetings with people all over England and Wales and all over the world online, so you don't have to be in Coleridge or Crediton area. And that's pretty much 20 minutes or so, a view into my world and things that I deal with. I'm happy to open the floor to general questions, and as I say, if you've got anything more specific, more personal, by all means contact me, and you can speak confidentially and privately. So I don't know if anybody has any questions.
Can I ask, the power of attorney?
Yes.
For instance, my husband and I are quite fit at the moment, but we're in our 70s, and I'm thinking we ought to put something in place. Can we appoint one power of attorney, one of our sons, say, to be our power of attorney?
Yes, you have a number of options. What I would say is, from a general point of view, it doesn't matter who we're talking about, but we should always appoint at least one primary choice attorney. And if we're only choosing one primary choice, we should also choose one substitute attorney, just in case. Now, the reason that's important is, I have come across older powers of attorney where two spouses have appointed each other and that's it. So if one of them dies, the survivor has no attorney. So you would always have either one primary choice and at least one substitute, or you could have two people acting together, and if one of those is a generation younger, then statistically they're going to outlive us. So it really depends on the family dynamic, but usually, more often than not, people will say, well, my first choice is my spouse, but if my spouse cannot act, our children. So yes, you can choose whomever you want to act and under what circumstances. Anybody else like to ask anything?
Joint home ownership.
Yes.
For unmarried people, and inheritance tax. So if they are joint tenants,
yes,
and one dies, is the property subject to inheritance tax? In the same way as tenants in common, if one dies, then it's half of the property is taken as part of their estate, isn't it?
Yes, that's a good question, because the value would be the same. So although they're treated differently from a procedural point of view, it's the value. So in other words, if you have two people who were partners, and it doesn't matter which way they own it, because the deceased's share will be part of the calculation for whether their estate is subject to inheritance tax or not.
So it is the same.
Yes, so from a tax point of view, it's a good question, because it doesn't make any difference. However, what you have also touched upon is if you've got two partners who are joint tenants in common, and sometimes people don't even realise they've bought a house that way, no wills, one of them dies, and then the survivor then is co-owning the property with parents or brothers and sisters of the deceased rather than each other. So there are all sorts of running just under the surface potential nightmares that people do find themselves in, but from a tax point of view it would be the same calculation.
I was just going to say, power of attorney, there's kind of two sections, aren't there? One is someone been given permission to make financial
Yes.
decisions, and the other one is being given make decisions about care.
Yes, that's correct. So you have two separate documents, going back to the examples I used before. So one of them would be that if you and your spouse or you and your partner co-own a property, you'd be well advised to have power of attorney for property and financial affairs, so that the partner or the spouse who is not ill isn't locked into that property because their co-owner cannot sign to agree to move house or to adapt the property. So that would be under the terms of the property and financial affairs power of attorney, and the health and welfare, as we went back before, regarding wrongly being told you've got to pay for your care. Under health and welfare power of attorney, your attorney could say, no, I can appeal, and they have the rights as if they are you. So they can basically get your medical records to prove that your needs are primarily health related, not just socially related. So yes, two separate documents, but they're under the same title, power of attorney.
But the care side or the health side, they can make decisions on your behalf, can't they, about your health,
Yes.
treatments.
Anything to do with your health and your welfare, because legally they would then, if you've lost your mental capacity, they legally are you. So they can be as vociferous as you would be if you were able to. I don't mean you personally, I mean the person I'm talking about. They will act legally as if they are the patient. So they can obtain medical records, they can discuss all sorts of care options with local authority, with the NHS, as if they are the person who's lost their mental capacity.
What about DNR, do not resuscitate?
Well, that's, yes, a very controversial point. And it's very important to be aware that you've got an emergency do not resuscitate option and a more long-term do not resuscitate. So the two are different, because under a power of attorney, you cannot, or nobody would in any good conscience say, oh, if I get hit by a bus, don't resuscitate me, because that's an accident you couldn't foresee. So the do not resuscitate under the health and welfare power of attorney really relates to, if I've got to a position where medical opinion confirms that I'll never regain consciousness, I'm brain dead, so there's no hope that I ever recover, and my attorneys believe I no longer have the quality of life that I would have wanted, minimum quality of life I would have wanted to have, I would prefer not to be resuscitated, and I would prefer not to be kept alive artificially. But you can't compel your attorneys to end your life. Do you know why? Because currently it's illegal. You can't currently ask someone to end your life. Now, my personal view is, and it's purely political, is that as time goes on and there's more and more pressure on hospital beds, and what are we going to do? We haven't got enough hospital beds. Well, if we were to sort of say, well, this person, why don't you just, we've got more hospital beds, and I think money will play a part in it. That's only my personal view. I hope not. I hope it doesn't happen. But like most things in law, it changes because of financial motivation. But as it stands, thankfully, you can only express it as a preference to say, I don't want to be kept alive if there's no hope, but that's not the same as don't resuscitate me if I get hit by a bus, because there's a good chance you'll recover if you're resuscitated under an accident or something like that.
Most people would think if they need a will or power of attorney to go to a solicitor,
Yeah.
and I presume you are not qualified as a solicitor, but you have qualifications to write wills, do power of attorney?
Yes.
And how are you actually regulated? Do you belong to a professional body or?
Yes, that's a series of questions there, actually. So, because to arrange a will, we can do it ourselves if we wanted to. We have the knowledge. Like we can do our own dentistry and do our own car mechanics, etc. We don't because we think there's somebody else in this sector, or do our own minor surgery. I'm what's called a professional will writer, with a professional estate planner. I'm a member of the Society of Will Writers, which is a self-regulatory body. I have to be insured against making an error in a will or a power of attorney. We also have to adopt a code of practice, confidentiality, etc., etc. I've been doing this since 2005. What I would say is that sometimes people will say to me, are you the same as a solicitor? To which I will always respond, how dare you? Because having seen many wills, I work on the premise that I am the same, you'll get the same end result as you will if you go to a high street solicitor. In reality, I know that I'd like to think you'd get better, because sometimes I'm dealing with wills as part of a probate application, and Andrex would be embarrassed by the quality of the paper that's been used on this will. There are errors, mistakes, spelling mistakes, etc. So I am a professional will writer. I'm not a solicitor, but I do have to answer to these people, the Society of Will Writers, who are a professional regulatory body. And I have my own complaints procedure internally, so if somebody says I'm not happy, of course we'll deal with that. And if they're still not satisfied with the client, they can then go to the Society of Will Writers, who will even put somebody else in place to do or to finish the will at no extra charge. So there's a lot of support behind this, but I'm insured. So even if I'm long gone and I've made a mistake in a will that costs a family money, my insurance doesn't end when I retire or when I die. The insurance is forever. So the insurance covers any losses. So you haven't got to just rely on my expertise and my professionalism. I'm fully insured against errors as well. But my driving force is client satisfaction, because if I've got a satisfied client, they're far more likely to recommend my services to someone else. But I'm not a solicitor. I couldn't represent you in court if you were up to no good.
Okay. No, I just, in my particular case, my partner and I, we made wills several years ago when we were living together as partners. We've been together about 34 years. But last year we actually did a civil partnership.
Oh yes.
Rather than get married, which I presume is exactly the same as getting
legally
married.
it's the same thing.
And I wondered whether we could just sort of copy some things will have changed slightly. We had basically mirror wills.
Yes.
If we just could we write it ourselves by just sort of taking the old wills, which we have copies of?
Yes.
Well, yeah.
It would have to be the original document.
Because I know we've got to remake our wills because of the fact that we've got, we entered a civil partnership.
Well, yes, your wills at the moment, as we speak, are revoked. You can what's called republish a will, but it has to be the original document, not the copy.
Right.
And all you do is you just basically have to re-sign and have it witnessed,
Yeah.
and make the declaration again that this is my last will and testament. With technology as it is now, you probably find it's neater and easier just to reprint your wills again and then just do them as if they're brand new wills. But you also have to have a particular clause in there relating to the fact that all previous wills have been revoked.
Right.
To make sure that the will that you are now creating is your only existing will.
So that would be something that I'm sure you can do more complicated things as well. But that would be a relatively easy thing to do.
Yes. There used to be a thing that was called a codicil. Now, if you go back far enough in history, all wills were handwritten. So you wouldn't want to pay someone to handwrite out another will, so you just say, well, I only want to make a couple of changes. So what would happen is that the legal person would just do an extra page, which was called a codicil, which was basically just saying, well, the previous will, all of that, but this has changed, and re-sign and re-witness. But with technology now, it's no more expensive to just have a brand new will, and it brings into any more modernised legislation, etc., etc., etc. But yes, it is something that we do. Also, what I would say is that do you share children?
One, yeah.
Do you have children of your own as well?
No.
Okay, well, just for that example, it wouldn't make as much of a difference, but people who say have remarried and have their own children, it's also important to put in the will to say, if we share a house, I don't want my half of the property accidentally going to your children, no offence, vice versa. You also have to then make sure it's a little bit more complex to say, this is how we protect against that. But yes, in summary, it's something that we do on a daily basis, but I'm not here to promote my services.
That's fine.
But
That's okay.
very welcome to.
Thank you.
So has that answered everybody's questions? So I think we've pretty stuck well to the time it is now. So
That was the football.
oh yes.